Okay, we're live. Welcome. This is our first Zoom webinar, so bear with us. I'm really proud of our team for pulling this together so quickly. Welcome to Biz 417's Paycheck Protection Program webinar presented by BKD CPAs and Advisors. I'm Logan Aguirre, President and Associate Publisher of Biz 417. So we're small business owners, and the past 3 weeks have felt like 3 years due to the impact of the COVID-19. The financial consequences that this pandemic will have on businesses of all sizes is unsettling and unpredictable. So that's why today we wanted to take the opportunity to talk to you about the Paycheck Protection Program within the CARES Act. A lot of you sent in questions, really good ones. We'll get to those today. The ones that were specific to the SBA lending process and the SBA piece, we're not going to cover in depth on this one. There's still a lot that needs to be figured out, and we hope to do a follow-up on that one. So we have over 300 people with us today. So thank you so much, BKD, CPAs, and Advisors, for jumping on board so quickly to share your expertise. Today we have Corey Stone, a manager at BKD, CPA, and Advisors, and Nathan Fitzgerald, a senior manager at BKD, CPAs, and Advisors. So Corey and Nathan, tell us a little bit about your expertise and your knowledge surrounding the Paycheck Protection Program.
Yeah, I'll jump in and start. I think when this bill was introduced in the Senate, I'm down in Branson, work with clients in Branson, Springfield, Joplin. Our clients were struggling mainly in the travel and hospitality industries, and so we were already looking at other SBA programs that they could be eligible for to get help. And then when this was introduced in the Senate, we jumped all over it and wanted to figure it out, wanted to know exactly what it meant for our clients, so we could start advising them on what was coming down the pipe as far as in Congress. I think from a big picture, it was something we saw a lot of our clients could take advantage of, not just travel, hospitality, tourism industry type things. And I'll let Nathan introduce himself and talk about how he sees it.
Yeah, so, as everybody's aware, I think the COVID-19 and the public health crisis has really affected a wide group of industries. There's, in certain geographic locations, there's no industry that's really spared besides maybe healthcare from feeling that impact with respect to gross receipts, employee headcount, all the stay-at-home orders. So as this was being introduced on the Senate floor and all the traction that it was receiving and attention it was receiving with respect to the Paycheck Protection Program, we felt like would be a viable option for a lot of business owners to get some immediate assistance. And then we started, as different drafts of the bill were coming out in different iterations, we started kind of putting pen to paper and running the numbers to see exactly whether or not there was going to be some cost savings on the side of the business owner, what the impact was going to be, and actually running through the mathematical analysis to figure out, what's going to be the end result if you do take advantage of this Paycheck Protection Program.
Thank you so much. I know we're in good hands today. We've had a lot of questions submitted, and so we're going to just start at the very top. First, just a summary. If you guys can summarize the Paycheck Protection Program for us.
Sure. So the Paycheck Protection Program, the way it is designed to work is to say that business owners should work directly with any FDIC insured institution to obtain a loan for their payroll. So the kind of broad strokes of the bill say you as a business owner would provide payroll information to the bank. They would then look at your average monthly payroll and multiply that by a factor of 2.5. So you would get essentially a loan for 10 weeks worth of payroll. And then you would be responsible for continuing to pay your employees over the covered period. And the covered period is going to be an 8-week period from the start or the date that the loan originated on. There's some nuances in the bill, and what we're going to share today is really based upon our interpretation of the bill. I'd say that it is a conservative interpretation going by the letter of the law. We're still awaiting final regulations from the Treasury Department, as well as additional guidance from the SBA as to the fundamental aspects of exactly how this is going to work. But what we want to focus on is kind of I guess, the computational aspects of the Paycheck Protection Program. And reading the bill itself is not as simple as to say that it's going to be gross payroll on an average monthly basis times a factor 2.5. So we've got certain items that are included in the computation of what payroll is, and certain items that are going to be excluded from what payroll really truly is. And by that, I mean that the bill defines payroll as wages, tips, commissions, vacation and sick leave, severance, health and retirement benefits, and state or local taxes assessed on wages, which we interpret to mean state unemployment. It is going to exclude wages in excess of $100,000, FICA tax, any type of federal income tax withholding, which is kind of a odd nuance of the bill, since every employee's federal income tax withholding is going to vary depending on how they fill out their W-4. And it's also going to exclude compensation to any employees with a foreign principal address, residence, and it's going to exclude sick leave eligible wages and FMLA eligible wages. From a size consideration, it's really limited or targeted for businesses that have less than 500 employees. But there is a caveat to that to say that based upon what the SBA has determined to be the size standard for a business's industry, there are going to be some industries that can have in excess of 500 employees. And that is certainly apparent with respect to our food service industry and our hospitality and accommodation industries under next code that starts 72. The 500 employee test is only going to apply on a physical location by physical location basis. From an eligibility standpoint, sole proprietors, independent contractors, and self-employed individuals are eligible to participate in the program, as well as tribal business concerns, veteran organization, and nonprofits. But the way that we interpret the bill is to say that self-employed sole proprietors, at the end of the day, we're still going to have to look at their payroll tax filings and whether or not they're actually paying what would be deemed to be payroll or wages in order to compute how much loan they should receive.
That was one question that had come in, was if you're self-employed, what proof for your loss of income is required?
Yeah, so as we're talking through self-employed individuals, again, I think it's really designed, again, a legal interpretation of the bill or looking at the legality of the bill would point to the fact that self-employed individuals can participate, but they're going to, the way that they're going to compute the loan is going to be predicated upon 2.5 times the average monthly payroll. So you think about it from a tax perspective, if you're a sole proprietor, the business operations are going to be presented on a Schedule C. As a sole proprietor, you would have an EIN, you'd file payroll tax returns if you have employees. And that's really where we think that the intent of the bill was to say that sole proprietors could get a loan if they have employees. And I think it's, from a loss of income, sole proprietors now, through the expansion of unemployment, are eligible to go and get and collect unemployment. So that's kind of a odd nuance of the bill.
I just want to say for housekeeping, if anybody wants to submit a question, make sure you're doing it to the whole group so that our moderators and everybody can see it. And if we have time at the end, we'll hope to get to those. So right now, is there a limit to how much can be borrowed?
There is a cap, and that cap is going to be at $10 million.
Okay. So a big part of this is the forgiveness of the loan. It's what's being talked about a lot. So how does this part work, or what paperwork or documentation will be required?
Yeah, on the forgiveness side, so you really have two calculations. You have the amount of the loan that you get up front, and then you have 8 weeks to spend that money, and that money can be spent on certain eligible costs that are outlined in the bill, and those include the payroll, which is all payroll costs that Nathan talked about a second ago that create the maximum amount of the loan. On top of payroll costs, you can pay utilities, which includes a lot of things. Telephone is included in that, your typical utilities that you think of: electric, water, sewer, gas, all of that. Rents that you pay, and then the interest on any mortgage obligation that you have. Now, on the rents and the mortgage and the utilities, it says in the bill that those service contracts or the debt obligation or the lease on the rent had to be in place prior to February 15th. So what they're trying to avoid is you running out and creating lease agreements or getting mortgages and then that being included. They're truly trying to say everything that happened before February 15th is an eligible cost that can be incurred on the forgiveness side. So when we get into the forgiveness, you have your maximum loan amount, and that's the amount of money you can spend on those eligible costs. The amount of money that's spent on eligible costs is eligible to be forgiven. It's not all forgiven. It's not just a simple, this is how much I spent, and now I get forgiveness on all of that. The intent of the bill was to keep your employees hired and to keep them paid at a rate that was comparable to what they received before. So on the forgiveness calculation, there's two parts to it, and you have to look at your full-time equivalents, which is some language that isn't specifically defined in the bill, but is language that was part of the ACA or the healthcare bill years ago that calculated the number of full-time equivalent employees as a comparison of the hours that they worked. And so you're comparing your full-time equivalent count during the 8-week period that you have to spend the money to your full-time equivalent count. And this is average monthly full-time equivalent account, but you're comparing it to the period of February 15th through June 30th of 2019, or you can elect to use the average monthly full-time equivalent of January and February of 2020. So that's going to give you a percentage that you can then multiply by the amount that's eligible to be forgiven. There's an additional reduction, dollar for dollar reduction on the amount that's forgiven for any employee who did not receive pay, who had a reduction in pay that was greater than 25% of the prior quarter. And the way the language is written in the bill, that's going to be an employee by employee analysis. Anybody that made more than $100,000 in 2019 is thrown out of that calculation. We think the intent is if you had executives that made more than $100,000 and they took a pay cut, for the good of the business, that wouldn't come back and hurt them in that calculation. But it is important to know, if you think about how the bill is written and how the terminology is used, you're comparing an 8-week period to essentially 75% of the prior quarter. And if you think of the prior quarter as a 13-week period, you're trying to pay in 8 weeks what you paid in 9.75 weeks of the prior quarter and not have a reduction in those wages. So as we've put pen to paper and walked through this calculation, if you simply keep all of your employees and you simply keep paying them the same amount of money for the same number of hours, the forgiveness calculation is not truly 100% forgivable. Now, that might have been an error as they drafted the bill. Congress got this through in 10 days, start to finish. They don't typically work that fast. But the original bill that was introduced on the Senate floor included the same language that we got in the final bill. The original bill, you were being paid for 4 months of costs, which would make sense with this language in the forgiveness calculation. So we may get additional guidance, or we may get an amendment out of Congress on the forgiveness calculation, but as the bill reads right now, that's how it stands.
Okay, thank you. So can we talk about any additional provisions in the CARES Act that impact employers from an employee perspective?
Sure. So I think one of the biggest provisions that's buried in the CARES Act that's going to have a dramatic effect on employers is going to be the expansion of unemployment. And on a state-by-state basis, the states have to opt in to the additional, it's the federal pandemic unemployment compensation. But from a political standpoint, most states are going to opt in. Here in the state of Missouri, we believe that St. Louis and Kansas City are really going to control that decision. They're experiencing dramatic or very high levels of unemployment. So we think that Missouri is going to opt in. If you look on the Missouri unemployment website, the language that's on there leads you to believe that they're going to opt in. That's going to afford the recipient of unemployment the ability to collect an additional $600 per week. So here in the state of Missouri, that's going to push our unemployment compensation up to $920 a week or $23 an hour. And I think that that's going to have a huge impact on industries where we have, I'd say, low wage bases, or where we have low skilled labor doing work. Our ability to either hire up if we need to, if we have already terminated, or our ability to keep and retain employees is going to be dramatically affected by that expansion in unemployment compensation.
So I know we have some questions about if you've already laid people off or reduced their hours, do you need to bring them back in before you know, to be eligible for the loan or to use the loan, or what's your advice on that?
Yeah, so I think you've got to look at it from the standpoint of, do you want the maximum amount of the loan forgiveness? And as Corey was walking through those provisions associated with loan forgiveness, it's going to be based on your average FTEs during the covered period, during the 8-week period, compared to 2 different measurement periods. And it's at the discretion of the borrower which measurement period they use. It can either be from February 15th of 19 through June 30th of 19, or January 1st, 2020 through February 29th of 2020. So you, as the recipient of the loan, get to pick those measurement periods. You're going to want to have a FTE count that is as closely aligned as you possibly can to your FTE quotient computed on the day that you receive the loan. If you've already laid people off, I think it really comes down to an economic decision. And by that, I mean, if we bring them back, are they going to be able to work? And are we going to be able to derive a profit from their labor? If we have already laid our employees off and they're essentially collecting unemployment compensation at $920 a week, you as the business owner can go and try to hire those people back in order to qualify for the maximum amount of loan forgiveness that you possibly can. But I would caution employers there, because the way that the bill reads would lead me to believe that you are going to come out of pocket in order to cover the payroll taxes and the withholding taxes that are due on those wages. From a fundamental aspect, the way that the loan forgiveness provisions work, as Corey mentioned, you're really, in order to qualify for the maximum amount of loan forgiveness, you're going to need to pay out 10 weeks worth of compensation over an 8-week period. And again, we could receive some clarification on that. You know, right now we're in an environment where we are basing our conclusions purely upon the bill as it reads. And Treasury is going to have some discretion on how they interpret the bill whenever they issue regulations. Unfortunately, I think we're going to be in a situation where those regulations are going to come out after the PPP program is live. You know, for all intents and purposes, we're hearing that banks are expecting to be able to start making those loans this Friday, which would be the 3rd. I don't think that we're going to have real clearly defined guidance with respect to some of the loan forgiveness provisions and some of the nuances that are kind of buried in the bill itself in the form of actual regulations.
So you can start applying for the loan on Friday. Any idea when the money would be available or what the time period is supposed to be there?
Yeah, so the business side of it is coming live on Friday. That was the guidance from Treasury yesterday. And when we say guidance that we got yesterday, it was a summary of the program that had a summary for lenders, a summary for borrowers, a summary of the overall program, and then a kind of an application that they could use. The banks could start to wrap their head around what information they needed to make these loans. No regulations or official guidance has been issued yet, but it's April 3rd for small businesses, and then the sole proprietors, self-employed, independent contractor. That group of people was April 10th, so next Friday for that group. So expect additional guidance between now and next Friday on a lot of these self-employed, independent contractor questions and what amounts are they using? Do I get to use, my income on Schedule C? Is it a average monthly self-employment income? Is it what I paid on 1099s? Those are all questions we expect to get answers to between now and next Friday. But as far as when it will be funded, that's a banking question that you need to talk to your banker about. Okay. The Treasury Secretary, his comment, and this was just a comment in a press conference, so you can't hold him to it, or you can't hold your banker to it, but the goal was to be able to fund in the same day if all the documentation was there and the application could be processed and approved.
Okay. So a couple questions that have come in regarding this. Does this apply to businesses of less than 50 employees?
Yeah, it absolutely does. I think the 50 employee number, whenever anybody who's pushing out like some talking points, that is really not a provision that's in the CARES Act. Rather, that's a provision that's in the Families First Coronavirus Relief Act, which is different, and that really deals with expansion of paid sick leave and expansion of FMLA coverage for those employers that have less than 50 employees.
Okay. So let's see. Oh, there's also questions about freelance contractors, if you include them in the payroll amount, or how you calculate the full-time equivalent.
Yeah, so, again, just basing it on a reading of the bill, a freelance contractor, by definition, would be receiving compensation on a 1099. And just reading the bill, that's not how they define salary. So your payments to freelance contractors, from my interpretation of it, would be excluded from the computation of how much you could borrow.
Okay. So as far as the one of the questions that you guys had put on here was, how do changes to unemployment impact the program and general business environment? Do you feel like you've covered that, or do you have more to say about that?
Yeah, I feel like we've adequately covered that. I mean, there's going to be a cost to this. As a business owner, you're now going to be in a position where you are competing with the federal government for employees. If that additional $600 amount is on top of the $320 that is offered by Missouri, the $600 amount would not be prorated in any way, shape, or form. It'd just be any recipient of unemployment benefits would qualify for an additional $600 per week. So that is going to put our businesses that typically hire individuals at low wage bases. Let's say you're going out and hiring folks and getting a lot of work done at $10, $12 an hour. That expansion of unemployment is going to have a dramatic effect on your ability to continue to hire people if you've already terminated folks, to bring them back, or to you know, over this period, and the expansion of unemployment benefits runs all the way through the end of July. So our ability to compete with the federal government, particularly here kind of in the Midwest region, I think is going to...
Are additional payroll credits available as a result of COVID-19?
Yeah, so there are some additional credits. There are really, I'd say we're paying related to 10 weeks worth of FMLA coverage or 80 hours of sick time under that act would make you eligible to receive a reduction in how much payroll taxes you needed to pay. And it is a dollar for dollar credit based upon how much you paid that eligible employee or eligible recipient. So you could end up in a net credit situation depending upon how many employees you were continuing to pay. The other provision that's actually part of the CARES Act is an employee retention credit of up to $5,000. There are some nuances behind that with regard to reduction in gross receipts in order to be able to qualify to receive that credit. And if you receive or accept money under the PPP program, you are going to be barred from being an eligible recipient of that up to $5,000 credit for employee retention.
Okay.
I'll jump in there and add that another piece of the CARES Act was the deferral of payroll tax payment. So you could defer paying, remitting your payroll deposits through the end of the year. Half of it would be due by the end of 2021, and the other half would be due by the end of 2022. If you pay Paycheck Protection Program, you're out of that program. So it's not as simple as just saying, go get the Paycheck Protection Program. There is an analysis that can be done to figure out which one of these programs apply to come out better on the end. And maybe it's not all forgiven, and I could have gotten these dollar for dollar credits in another program.
So yeah, there's a lot to evaluate before you just jump into applying for the PPP is what you guys are saying. Yeah. So I have text coming into my phone as well as, so here's some other questions. Most of my employees are tipped employees. Are their tips factored into my payroll cost report?
Yeah, they definitely are. Yeah, Corey, if you want to take that.
Yeah, reported tips are included. So anything that was reported is lined out in the bill as part of your payroll cost.
Can you guys speak just a little bit about the difference between this and the economic disaster recovery loans?
You bet. Yeah. So economic injury disaster loans, and those are going to be eligible for any business that is in an economic or declared disaster zone. And as we saw, I think it was not this past weekend, but the weekend previous, the entire state of Missouri now qualifies as a disaster zone. So you can make an application. The process is fairly straightforward. It is a program put together through the SBA. Those are EIDLs or EIDL applications under the 7B program. The maximum amount of loan that you could receive through the EIDL program is going to be capped at $2 million. And the application is made directly through the SBA. There was some immediate problems whenever Missouri got declared likely as a disaster zone due to the volume of applications that the SBA was receiving. Their website continued to crash. So we were instructing folks to make those applications via the paper forms, and you had the opportunity to either submit those via fax, or to mail it. And operational now. The way that we believe the SBA is going to compute how much of a loan you could receive is going to be predicated upon Schedule 2202. which lines out the monthly payments that you need to make on a monthly basis. And what we have been told in informal guidance is they're going to utilize that schedule, multiply it by a factor of 12 to determine the maximum amount of loan that they're going to offer or afford to businesses. There are some kind of nuances between EDLs and the CARES Act. And by that, I mean, we do believe that you cannot double dip. You cannot get a PPP loan for payroll and also have payroll as a listed cost on your EDL application. And we are continuing to wait for additional guidance from the SBA on kind of the interplay between the PPP loans and EDL applications. If you had already made your EDL application prior to the enactment of the CARES Act, I think that there was some back-end curative action that was going to be taken by the SBA to essentially push your, allow the recipient or the applicant to determine did they want to receive the funds through the EDL application, or did they want to receive through the. If we think about EDL, you can get up to 12 months of your payroll covered, whereas through the PPP loan provisions, you're going to get what is going to equate to 10 weeks worth of payroll covered. So I think it's going to be up to the individual business owner to kind of make an assessment as to whether or not it makes, from a business decision standpoint, whether it makes sense to go and get 10 weeks of payroll covered, or whether it makes sense with maybe a portion of it being eligible for forgiveness on the back end through the PPP program, or if it makes sense to go and receive the funds through the EDL application process that will have no amount of loan forgiveness. The terms of those loans are going to be at 3.75 over 30 years. And Corey, if you've got anything else you want to add to that.
Yeah, I'll jump in and address a couple questions that came in on the chat as well. But on the PPP loan, the amount that's not forgiven, it does turn into a term note. It's 2 years at 0.5 percentage point on those loans. And like Nathan said, on the disaster loan for businesses, it's 3.75, and for nonprofits, it's 2.75. Those unofficially, the disaster loan app or the disaster loan program allows for you to have that loan up to 30 years. We've been told by people at the SBA on different conference calls that they are essentially bumping those all out to 30-year loans. You still have to go through the underwriting process directly with the SBA, but expect to see relaxed underwriting and maybe a longer term than you would have gotten on another disaster loan if you have been through that program in the past.
A couple questions that have come in that I want to address. Can distributions paid to business owners as part of their compensation be included in the payroll calculation?
No, we don't. We don't believe they will be. The sole proprietor, independent contractor, that the wording in the bill is centered around self-employment income and 1099 income. Owner draw is just a distribution of income, not necessarily the income itself. So we do not think that will be any part of the calculation.
If you have a commission salesperson and their commissions and salary puts them over 100,000, is their pay disqualified from the calculations?
We really think there that the legislative intent was to say that it's wages in excess of $100,000. So you would not remove 100% of their wages, but rather you would push them down to $100,000 in order to compute the maximum amount of the PPP that would be afforded to you.
Okay, thank you. So many good questions have come in. So one person says, to clarify, with lower income employees, we are continuing to pay regular payroll. Is it better to lay them off so they can get an additional $600 on unemployment? And
yeah, I think you're honing in on kind of where this is going, and effectively your employees are going to get a raise. So you know, from I think that that's a business decision that you've got to make as to whether or not it makes more sense to go and get funds through the PPP based upon essentially what equates to more or less net payroll. Administer the payroll to your employees, therefore coming out of pocket in order to be able to do so, because you're going to have to cover the payroll taxes and any withholding taxes that are due. Or does it make more sense to allow them to be the recipient of unemployment? And that's I think, business case by business case type of decision. And it really, again, from my standpoint, goes back to, are you able, if you have employees, are you able to continue to derive a profit? If you are essentially barred from the market because your business is shut down, you are not going to derive a profit off of their labor. It makes no sense to me to come out of pocket to administer payroll to your employees.
Okay, I'm just looking through some of these questions.
I saw a question here come through with regard to unemployment. Will your unemployment or experience rating increase if you end up terminating employees due to COVID? Kind of had this scenario play out where I had a client that had an employee who went and filed for unemployment. I think it would have been like Sunday evening. Showed up to work on Monday. Went to the business owner and said, "Hey, FYI, I filed for unemployment. You can go ahead and fire me." And the employer was extremely aggravated. They had a lot of work that needed to be done. He intended on continuing to pay all of his employees. And he called the unemployment office, and he called them numerous times, finally got in touch with someone and said, "Hey, FYI, I've got this employee. They're not eligible to receive unemployment compensation. I've still got work for them to do." And they said, and again, this is just anecdotal and should not, I guess, be used broadly, but they said, "Thanks for calling. You can go ahead and terminate them now." And they said, on top of that, and it's out there on the unemployment website, the experience rating of the employer is going to remain unaffected. And I think what we're seeing is they have an extremely high volume of applications that are coming in. They also know that a lot of businesses are effectively shuttered. There's no one there for them to interview. There's no one there to respond to any type of inquiry. So they are pushing those applications through. They are not going to ding the employer on their experience rating, and they're just going to administer the unemployment. So I think we're kind of on a slippery slope, I guess I'd say.
Oh my. Okay, one question. Can you count outsourced employees like from a service like PenMac? Is that considered in your payroll?
Good question. I think it comes down from my standpoint to who the actual employer is, who's actually going to be responsible for issuance of W-2. So I don't think it goes back to the definition of common law employer. I think in order to support the PPP loan, you're going to have to provide payroll information. And by payroll information, I mean 941s, payroll registers. So if those are outsourced employees, I believe that those are not going to qualify. Corey, did you have anything to add to that?
Yeah, that's a question, I guess, or something that wasn't clear. It is important to keep in mind that the Paycheck Protection Program is coming in under the typical 7A program at the SBA. So it's being administered through that 7A program. And there's language in that 7A program that speaks to who an employee is and whether a PEO or an outsourced staffing company would count for that employee. I think it's the bankers are going to have guidance from the SBA as early as today is what we heard when that initial round came out from the Treasury yesterday. The SBA emailed all the bankers and said expect additional guidance within 24 hours. So to throw it out completely and say no, I probably not at this point, but there will be guidance, and that's a talk to your banker about that question and explain the situation, and then what are they going to need to document that situation.
Okay, a couple other questions. Can business owners file for unemployment?
They can. Yeah, so that was something that was expanded under the CARES Act, was the ability for business owners to qualify for unemployment compensation. Yep.
Okay. Nathan, could you just clarify, earlier you said you're essentially getting 10 weeks of payroll that you use in 8 weeks. So can you just kind of explain what that means by those extra 2 weeks?
Yeah, so the intent or the purpose and the way that this was presented on the Senate floor was to say, we're gonna take your payroll, however they define that, and whether it be net or gross, we're going to multiply it by 2.5. We want you to keep your employees employed for 8 weeks. That additional 0.5 increment was really meant to cover rent, interest, and utilities. But from a computational aspect, the way that this is going to work is to say that you have to compensate your employees within 75% of what they made in the prior quarter. And prior quarter defined as the prior quarter to the date from the loan origination. So if we really, what that's going to come down to is first quarter here 2020. And in order to kind of work through the computational aspects of the bill, I'd say you're going to get a loan for 10 weeks worth of payroll. By that, I'm saying average monthly payroll times 2.5. And you're going to need to, in order to afford yourself the maximum amount of loan forgiveness, render that payroll over the 8-week covered period. And I say that because we're basing it on 75% of what they made in the prior 13-week period. And if we just paid them straight pay, so over the course of 8 weeks, we continue to pay them straight pay, 8 divided by 13 is going to be 61%. You're going to miss out on some of the loan forgiveness.
So simple. Thank you.
Sorry.
So there's questions about like 501c3, C6 organizations, religious organizations. Who is able to take advantage of this?
On the Paycheck Protection Program, it defines nonprofits as 501c3, and that's it. That's the only nonprofit that's included. The disaster loan has a much broader definition of a private nonprofit. If you fall in that bucket, in the nonprofit bucket, and you're outside of the 501c3, I think you have to start looking at the disaster loan as your source of funds right now.
This says historically church employees are not allowed to receive employment benefits since the church does not pay state employment. Are there any changes under this?
Yes, there are. Unemployment was significantly expanded under the CARES Act to basically include everybody. So I would say if in doubt, apply for unemployment.
Okay, I read that loan payments for all existing SBA loans will be covered as part of the CARES Act for 6 consecutive months. Would it be wise for businesses to evaluate the PPP loan as well as other loan options when seeking relief? Can you speak to the loan payments for all existing SBA loans will be covered as part of the CARES Act for 6 months? So
yeah, the CARES Act did include that provision. So if you have an existing 7A loan or you have an application in for a different 7A loan, there is a provision where the SBA will make the payment on your behalf for 6 months. This Paycheck Protection Program is not included in that 6-month payment provision.
So you could still apply for the PPP?
You could still apply for the PPP, but the PPP, they're not going to make 6 payments for you on the PPP. Now, the PPP program is payments are deferred for 6 months, and then at the end of that 6-month period, any amount that's not forgiven turns into a 2-year note at 0.5 percentage point.
So there's some questions about the forgiveness part that the part that maybe isn't forgivable. If you could
Yeah.
just explain how that will be calculated or paid out, or how you'll have to pay it back.
Yeah, so at the end of the covered period, you're going to have to turn in information to the SBA lender to support the forgiveness portion. And they're going to then go through from a computational standpoint and compute the amount that's forgiven. We've seen some guidance from the SBA to say that they are expecting to be what they deem to be oversubscribed. And I think by that, here in the bill, we've got $349 billion allocated to the PPP program. But I think what they are expecting is to say that they might end up in a position where they make PPP loans in excess of that. So there's going to be a level of oversubscription. And if they do that, they, from the guidance from the SBA and on the SBA PPP program loan application that we've seen, just kind of in its draft form, you as a borrower have to sign off on the fact that you recognize that they might end up in an oversubscribed position, and therefore, if they are oversubscribed, they might even further reduce the loan forgiveness. Now, that is not anywhere in the bill. There's nothing in there to say that if they're oversubscribed, you're going to get billed back. On the forgiveness portion, it's two different measures. The first is your average employee headcount on the date that you get the loan. The second measure is at the discretion of the borrower, the average employee headcount either from February 15th, 19 through June 30th of 19, or January 1st, 2020 through February 29th, 2020. Then there's a second loan reduction feature that says that you have to pay over the covered period 75% of what the employee, and it's on an employee by employee basis, 75% of what they made in the prior quarter or the prior 13-week period. So we've just kind of run through the math based upon our interpretation there. And it's not an all or nothing that, for that secondary. I saw that come through the chat. It's not an all or nothing to say that if you don't pay within 75%, that then you would not qualify for any loan forgiveness, but rather the amount that you don't pay within that 75% is there's going to be some feature of loan reduction associated with that.
So if you're normally paying people for 40 hours a week and you really only have 30 hours of work, can they apply for unemployment on the difference?
I think that comes down more to a legal question of the definition of what a furloughed employee is. Fundamentally, I think that you could furlough them, but I think it's going to be based upon kind of their job classification, and that's more of a question for a labor attorney.
Okay. Do businesses have to prove that they've been adversely affected to qualify for any of these programs?
They have to fill out a self-certification. There's language in the bill that says basically everybody's been affected by COVID-19 in some way. I don't think anybody will be denied because of that, but that's a banking decision. I don't want to speak for all the bankers out there either. So,
okay. How do you calculate on full-time employees for part-time employees?
How do we calculate?
For Paycheck Protection Program, how do you calculate on full-time employees for part-time employees? So if you only
I'm reading the question. I think, how do you calculate full-time equivalents for part-time employees? That's a really good question. So nowhere in the bill does it define FTEs. Now, on your initial qualification standards to say that it's an employer with less than 500 employees can qualify for the PPP program, they outline and say that it is pure headcount. So part-time employees, full-time employees, all of them are added together in order to determine whether or not you are an eligible recipient of the PPP program. We believe that the intent by saying average number of full-time equivalents would default back to the language that's in the ACA provisions, which says that it's you would take all employees who are working over, I think it's 30 hours, those would all count as full-time employees. Then anyone under that threshold would be added together, and then you would divide by the number of hours to reach the equivalent portion of full-time employees. But in the bill, it doesn't reference, or it doesn't point towards where we're going with respect to the definition of full-time equivalents. And I think we're going to need some additional guidance in the form of Treasury regs to ensure that we're computing that full-time equivalent the correct way.
Okay. We just have a few more minutes here. I see a lot of questions that I think have been addressed maybe just earlier in this, and this is being recorded and it will be on our website, so you can go back and read it. We're also going to be sending out a recap. So I think some of the things I'm seeing in here we did address earlier. You just might have missed it, or it's so much information that it might just be rewatching it again will kind of help break anything down for you. Is there anything else you guys want to add or that we haven't covered that you know you've been getting questions about?
Yeah, there's a couple of additional, I guess, considerations in this bill, and the bill itself is 880 pages. It's a huge volume of information, but embedded in that legislative bill under the CARES Act, there are certain provisions that are going to affect businesses from a tax standpoint, and it's going to impact tax returns that are maybe in process right now. Maybe you've already filed your 2019 tax return. It could end up impacting even previously filed tax returns, so going back here several years. So that's a consideration too. It has to do with respect to NOL carrybacks or net operating loss carrybacks. Has to do with some technical corrections with respect to what they deem to be qualified improvement property and the depreciable period associated with qualified improvement property. So there's some other, I guess, issues that a business owner might want to consider and work with their financial advisor to address whether or not those are going to impact them as well.
Thank you.
Yeah, and I'll echo Nathan's thoughts. I mean, this isn't a one-size-fits-all. There's no standard answer for any business. A lot goes into the decision on how to handle this, and the forgiveness piece is not all or nothing. There is a calculation, and some can be forgiven on the Paycheck Protection Loan. That question came up a couple different times, so we'll get that addressed there. But shameless plug, BKD is doing a webinar series for the next, 10 weeks, I think is what it's set at, related around COVID-19 and some of the laws that are coming out and things to help businesses. Friday, there's the webinar is SBA loans, payroll tax credits, things that were discussed here will be discussed again there. And then I think you guys are posting this video again. So a lot of information out there, a lot to consume. Be in touch with your CPAs, with your bankers, with your advisors to really understand what this bill means and how it impacts your business.
Thank you guys so much. I know it's a lot of information to digest, and I appreciate you guys helping just, create any kind of clarity or help around a lot of our small businesses that are maybe navigating this alone if they don't have a really trusted advisor. I know tomorrow's Good Morning Springfield that the Chamber is hosting is going to be about, there will be some portions about this and the SBA process. And there's a lot of questions regarding the application and how to evaluate a lender and those sorts of things coming through. And we would like to follow up on a separate webinar that's more SBA focused. But there's still just so much confusion and clarity. We need more clarity there to have an expert on to talk about that. But thank you guys so much. Thank you, BKD, for being a great partner on this, and for you two taking time. I know you have, I'm sure your phone is blowing up with all of your clients that need your help. So thank you for taking an hour of your time to help our local business community. And if you don't subscribe to Biz 417, I would love to give a shameless plug to ask you to subscribe. You can do that on our website, biz417.com. Sign up for our e-newsletters too. But on behalf of the entire team at Biz 417, thank you so much to BKD, and thank you for everyone for joining us today.